Hey, Brian Douglas here. This week's blog is about understanding the role of bankruptcy or a bankruptcy proceeding in a real estate transaction. So for consumers, there's primarily two types of bankruptcies you can do. There's a Chapter 7 and a Chapter 13. So Chapter 7 is what's called a liquidation, and a Chapter 13 is a reorganization. So in a Chapter 7, you're kind of getting rid of everything. You're saying, I've got so much debt, I don't have any assets, I don't have any money, just make it all go away and I want a fresh start. And it's a totally legitimate thing to do, and people do it every day for a multitude of reasons. A Chapter 13 is I have a lot of debt, but I have assets and I want to reorganize that. I want to restructure that. So they're two very different bankruptcy proceedings that require a lot of different work that a skilled bankruptcy attorney can walk you through if you are actually considering bankruptcy. But the question is, what happens if there's real estate involved in that bankruptcy? And believe it or not, this happens quite a bit. So people file bankruptcy, but they own a home. So what happens at that point in time? Well, it depends. And the first and foremost is, if the bankruptcy is pending, then the only way the transaction can go forward is with the court permission, right? Once the bankruptcy is going, once the bankruptcy is in play, the court has jurisdiction over the assets, for lack of a better term. So the person that filed bankruptcy can't just go and sell it during the middle of their bankruptcy. You've got to get permission from the court, so you want to make sure you do that. There's also, in a bankruptcy, there's a key role called the trustee, and so the trustee is there to look out for all the creditors, right? Because in bankruptcy, we're trying to deal with our debt and get rid of our debt, and the debt is, of course, belongs to the creditors. So the trustee is the person appointed to do that and handles that for the court. So you also need the trustee to sign off on that. Depending on how much equity you have and things like that, the trustee may allow the sale to happen, but they may want some of the money. They may want some of the proceeds, and they may say, yes, Mr. Seller, you can sell the property, but you're in bankruptcy, so we get all the money. And the seller would sell the property but not get the money back, and it would just pay off the mortgages and the debt. So it's super important to understand what type of bankruptcy it is and what's going on. And most importantly, like I said, if you're looking at buying a property or selling a property in bankruptcy, understand because of the approval that you need from the court and from the trustee, it's not necessarily going to be a quick process. It's going to take time and a lot of vetting, and it has to go through the procedural channels inside of the actual bankruptcy court in order for it to be a valid sale. So if you have questions about bankruptcy and real estate transactions, check out this week's blog. We're always here to help if you have any questions about that, or if you need any help with bankruptcy. Certainly glad to refer anyone to anyone that we possibly can. We know some great attorneys out there to help guide you through the process. That's all we've got for this week, and we'll see you next week.